The trial judge said code is speech. Now what happened was basically the government backed down.
Encryption was literally deemed a weapon, a munition.
Yep.
And therefore they said you are exporting weaponry.
Right. Code is not just speech. It has conduct elements to it.
But
right?
this is like the whole ghost gun argument. The plans are not the gun. The plans for a bomb and the plans for the lower receiver of a weapon still are protected.
The government gets to draw lines on how much usage is illicit before they're going to regulate the speech. Again, it gives me hope because we have tools like Bitcoin that do provide financial freedom.
If I was a government official and I was hell-bent on just completely stomping out Bitcoin, could they do what they did to Tornado Cash and just say the entire Bitcoin blockchain is now on the OFAC list?
Theoretically, they could.
All right, guys, bang, bang. I've got Aaron here with me. I'm very excited about this because it seems like a huge debate in society that has happened in the past but is resurfacing. It's this idea of software being free speech and being protected by the First Amendment. You have a specialty in understanding a lot of this, but I thought a great place to start would be the kind of quintessential legal case of Bernstein versus the Department of Justice, which really set the precedent for code being free speech. Help us understand, like, what should people know about that specific case that really laid the precedent for some of the things that are happening today?
Yeah, so it's really interesting, and I didn't know as much about it until recently, and I started going back and researching, the crypto wars of the '90s and the formation of the cypherpunk movement, and all of this. That's where all this started. And it's interesting to know that the Bernstein case, Bernstein was a professor and had basically created an algorithm, right? Encryption and decryption algorithms, and also had an academic paper on it and wanted to publish the paper and, publish the algorithm. This was his, he worked on it as a graduate student and wanted to put the information out there and teach on it. And so at the time, you had these really strict export regulations. Cryptography was classified as like a munition. So you had to get pre-permission from the government. At the time it was State Department, and then it shifted during the litigation. It was moved to different departments and things like that. But you had to get pre-permission to essentially export these munitions, encryption algorithms, right? And so he sued the Department of State to get permission to do it. Well, he sought permission, they denied it. Within their boundless discretion, which then became really important to the decision because the trial judge, Judge Patel in the Northern District of California, said that first there were actually a series of orders that she issued. The first was code is speech, and that's what everybody thinks of when they think of Bernstein is, the source code is speech. Then the next order was summary judgment in favor of Bernstein because this scheme of boundless discretion within, an agency determining whether or not to license the speech, it just violates the First Amendment. There's got to be, you can have time, place, manner restrictions on speech, right? Noise ordinance stuff, right?
Yep.
But there's also got to be, really strict judicial review and a method and a process for reviewing the discretion of the agency that's licensing speech, basically. So that was the first part of it. Now what happened was, and this is what I didn't realize either until I started looking into it more deeply, those are trial court orders.
Okay.
In terms of like order of precedential value, those are pretty low compared to something like the Supreme Court case, which would be the highest precedent in the land. Every single court has to follow it, even the state courts. Then you've got the intermediate appellate courts, and in this case, it was out in California, so it was the Ninth Circuit Court of Appeal. The Ninth Circuit did issue an opinion affirming, but what happened was the government asked for rehearing, which means rehearing en banc, which means you get most of the judges together instead of a 3-judge panel, really big decision, and get all of the judges to weigh in on the court. So they rescinded, the Ninth Circuit rescinded the affirmance of the code of speech, orders, and then never got around to issuing an en banc opinion because in the interim, basically the government backed down on
So Bernstein basically said, hey, I'm going to release this code, the source code, along with a white paper, essentially. And it was related to encryption.
Yes.
At the time, encryption was literally deemed a weapon, a munition.
Yep.
And therefore, they said, you are exporting weaponry.
Right.
Even though it was words in a database. And he said, no, I'm not. I am speaking.
Exactly.
I'm using words.
Yep.
And so they went to court, as these things tend to do.
Yep.
One, just like, how about the balls on Bernstein to go against the United States government around weaponry or words?
It is. Bernstein, all of these, the cypherpunks and folks who were cypherpunk adjacent, like Zimmerman, who created PGP, like Zimmerman, went not only against like the government and the NSA and stuff, like he went against like the patent holders of these encryption algorithms, public key, private key encryption algorithms. RSA was the company that had a lot of the patents, and we could get into, how a lot of people think that, also delayed the public's use of encryption, because you not only had the NSA trying to, in the State Department preventing, private use of encryption, but then you also had patent holders who had the most powerful, encryption products, as
and was the thought
property.
process that encryption essentially allowed for their use cases, but they didn't see the use case for like the individual to have privacy?
Oh no, they saw the use case.
They just didn't want to have it.
Exactly. It was that the trade-off, privacy to the NSA and the government was, a sacrifice they were willing to make, on behalf of the American people to keep people safe. Right. That was the idea, is that we can't let terrorists and arms dealers and, foreign adversaries have this, important shielding technology to shield communications, because then it's going to make America less safe.
Got it. And so as Bernstein went to court, wins kind of the court case, there's these two distinct and different kind of judgments, if you will, or outcomes. One, code is speech, and two, the U.S. government can't just say like, hey, we make up the rules as we go.
Exactly.
Why did the government back down in some of the appeals process, or eventually not take it to the Supreme Court or whatever? Like,
what happened was Bernstein essentially lost his standing, and the issue became not ripe. Was one of the final rulings in that saga, because the government essentially just let him.
Just said, hey, we're not going to win to some degree. And so rather than catch the L.
Yeah, it was probably a strategic decision. Yeah. And so then what you had two other decisions that were subsequent to Bernstein. One from the Sixth Circuit Court of Appeals called Junger. And Junger was also almost same fact pattern as Bernstein. He was a Case Western professor who had, algorithms and papers he wanted to publish, and ran the same playbook. And that actually did get an opinion. Code is speech. Now, the problem was it was much more limited and kind of problematic. And I think this is a nuance that a lot of people are missing today in the discussion about code being speech and, First Amendment rights protecting code. The Junger court said code is not just speech. It has conduct elements to it.
Okay,
right?
Explain that.
You've got source code, which is speech, but then you also run the source code through a compiler and click a button, and now your program, just decrypted DVDs or whatever it is. So there's a conduct element to it that, the person who's receiving and running the software isn't reading the source code. It's not communicative. It's conduct. And so the government, Junger said, should be able to regulate the functions of code if they're doing it in a way that is content neutral as to the speech. So
is this like when you get into like the ghost gun stuff, where it's that's the code for, or like the plans of the ghost gun itself are protected by the First Amendment.
Right.
But then if I download it and I go and I create a 3D printed gun, that would be more of this idea of like there's
functional component.
There.
Yeah, this conduct and function. And then so we'll put a pin in that. We'll come back to that. The other case was in the Second Circuit, which is overseas New York, and so they get a lot of the financial type litigation. But this was Universal Studios brought an action not under the export laws, but under DMCA, which we're all familiar with, the strikes and takedowns and stuff. But there's actually a provision in DMCA that says circumvention technology that's designed to circumvent digital rights management encryption that prevents you from playing a Japanese DVD on an American DVD player. That technology was the government could get injunctions to enjoin publishing that circumvention technology that's circumventing rights, copyrights, and things like that. And so I don't know if you ever read the 2600 magazine. It was like a hacker quarterly. 2600 magazine. It was a little like 10-inch pamphlet magazine. In high school, I got it. I'd go find it and felt like I was, like on the edge, like, living the cypherpunk dream because I was reading about, I barely knew how to code. I was just, messing around with computers and stuff in high school. But the publisher, the editor of 2600 was publishing DVD decryption algorithms.
Got it.
He didn't write them, but he was publishing the code and publishing links to the code on 2600's website. And Universal Studios came in and sued him to get an injunction to stop that decryption software from getting out. And the Second Circuit said the same thing as Junger's, that there's this functional component to code. And so if the government is going to regulate the functional components without, obviously regulating the speech elements and saying what you can and can't necessarily.
What is the difference here?
Yeah, it's a difficult distinction to bring up. The function was, essentially circumventing copyright regimes.
So you can have the code, you can
you can look at it, you can look the code. Yeah, you can look at the code. There, I think the actual ruling was, they couldn't 2600 couldn't link out to it and disseminate it that way. But there's not much of a distinction. Let's put it that way.
Yeah.
The Bernstein decision, Judge Patel's decision, was the more principled, I think, because what the Junger court and the Corley court were saying was that the functional aspects, we're going to use these tests to analyze whether or not the functional aspects can be regulated. We're going to use these tests that came out of like the flag burning and the draft card burning cases, which Judge Patel also looked at and analyzed that argument and rejected it and said, regulating flag burning and nude dancing is so totally different from regulating source code. The analogy just doesn't fit because, and this is something that Peter Van Valkenburg at Coin Center has written on too. And he also agrees, with Judge Patel's reasoning.
Which is
that
code
is pure
protected.
speech. Yeah. And there's some conduct elements to it, but it is a medium of speech.
And the part that I describe to people is like, you write words in a database.
Right.
And so if they are going to say you can tweet or you can write on paper or you can write into a database, it seems in today's day and age that is all speech and is protected. Right. Where we get into this weird world is, and really kind of the conduct component, I think a modern day example is this idea of tornado cash.
Yeah.
Where my elementary view, or the way that I would describe it to somebody is an engineer wrote code. That code allows for people to use it and do things with it. And there's a lot of people who say, hey, that's protected by the First Amendment of the United States. Right. Because code is speech. Maybe it's not as black and white as that.
It's not as black and white, unfortunately. So we're stuck with the Corley and the Junger, functional distinction with code. And so that's where tornado cash, now there's a lot of different issues with tornado cash.
Okay. So
we can peel it apart, but that is where there's wiggle room for the government to regulate code in certain ways.
So Tornado Cash, for those that don't know, is a mixer, which at the most basic sense allows you to take the information on the blockchain. The sender is very clearly able to track funds from sender to receiver, right? Is the whole idea of a blockchain.
Right.
Everything's
Open, transparent, yeah.
Everything's written there. It's immutable. It can't be changed, etc. A mixer, in the most basic form, says the information or the value of the transaction from the sender to the receiver is now not as easily trackable. And the way that that's done is you can send economic value into the mixer. It mixes your funds with somebody else's or many other people's. And then the output is appears to be random to somebody looking at this, but you're able to direct it as the sender, and the recipient still receives the value that you want them to receive. Walk us through like the analysis of software as speech. But it sounds like the government drastically disagrees. We've now seen them invoke OFAC. There's been a developer who was arrested. How do you look at a situation like this?
So I guess let's just reset what happened with Tornado Cash, and OFAC is the Office of Foreign Asset Control. That's the Department of Treasury that hunts terrorist funds basically and money launderer funds and tries to tamp that back down. And so they have a list of, specially designated nationals, has to be foreigners, can't be Americans. And if someone's put on that list or someone's bank accounts are on that list, Americans are on notice, they cannot transact.
So Americans can't be put on the list.
Correct.
But if you're an American and you transact with or engage
then you can be liable.
Yes,
under the regime. There's like civil penalties. There's also some criminal penalties. This is not an area of law. Compliance is not my area of law, but I've been following along.
Slept at a Holiday Inn.
Exactly. I slept at a Holiday Inn last night down the street, and it's all good. So OFAC though, as far as I understand it, is authorized by its authorizing statute to add entities and individuals to that list, that SDN list of sanctioned, the sanctions list, and then the essentially, account aliases of those individuals and those entities. So let's talk about what happened with Tornado Cash. Tornado Cash, scare quotes, is what was the first entry on the list, and then the website. Let's for purposes of the discussion just assume there is an entity, a group of people called Tornado Cash. Sure. Call it, people like to get into like, well, it's a DAO and it's not a real entity because it doesn't have legal rights. It's like, well, DAOs are all kind of general partnerships under most state laws. Like if people get together, or joint ventures, if people, you and I get together and,
it's kind of like a contract is if you and I can have a verbal contract, even if we didn't paper it, if you and I start working together.
Unincorporated entities. We can have, full liability for our enterprise that we start working on. So let's just say Tornado Cash is an entity. Sure. The website being added to the list, I guess that's the front end. So, you can't go in and transact through that front end if you're an American. And then there's this list of Ethereum addresses on the blockchain. I didn't understand this at first because I'm not really steeped in, how Ethereum works. I mean, I know it's smart contracts and Turing complete and all that stuff. And, but some of those addresses were like donation addresses for the project. And so presumably there's like an admin key that someone holds and there's some control, or the DAO holds or something, there's control over those. Others though were just the address where the smart contract of the mixer exists, right? Where you call on the contract at that address, that's where you send your funds. That's how the mixer works. It would be like listing, the Cal Berkeley server where Bernstein's algorithm was.
Got it.
Right? That's essentially what happened. Now, where we get into whether or not that was authorized is that property of Tornado Cash? Like they can't change that code now. It's like you said, it's immutable and it's on the blockchain, right?
This is very similar to like Uniswap has the front end, which is controlled by the Uniswap entity, and they have made changes. They have responded to regulation, but theoretically, the Uniswap smart contract cannot be changed, shut down, et cetera. And there's, I don't know, 50 to 100 other interfaces that leverage that, almost back end.
Right. The front end, you can point to whichever smart contracts, you want. But, if someone knows the address of the previous smart contracts, they can just go access those smart contracts. Just like, you change the links on your websites, but, if you don't take down the original, page, and you remember the link, you can go access it.
So let's go through this part by part. So Tornado Cash, there's a group of individuals, right? That the organization, whether incorporated or not, that gets put on the list. That seems to be, based on your analysis and maybe others that I've seen, well within what normally would have been expected by OFAC.
Yeah.
Okay.
Exactly.
Then there are what I'll call those individuals' accounts, which is equivalent, although different, but equivalent to their bank accounts in the legacy financial system. And so if the people or the group is going to be put on the list, then you would expect their accounts to be put on the list.
And the analogy, this happened recently with Blender.io, which was another mixer that was custodial, meaning,
you sent your funds.
They had a lot more, contact with the actual users who were using it, and were just taking it in and then remitting out. They had a lot more discretion over what was going on. It was the same, these announcements and the listings mirrored each other. And in the Blender.io, there were Bitcoin addresses that were listed, and the entity that ran Blender.io presumably had the private keys to those addresses.
So let's stop right here for 1 second, because there's a couple of questions just at like the highest level around the U.S. government stepping in and saying, no mas, right? This is not good. Their argument, from what I read, is that there's North Korean hackers who were able to launder funds using these products or this technology. And that was really the impetus for why the government was stepping in and saying, hey, this isn't allowed. If that was not the case, let's say that there was no trace of North Korean hackers using the technology, it is unclear whether they would step in and say, you cannot use this, you cannot do this. There's a lot of people who would argue, no, they were just looking for a reason to step in and shut this stuff down. There's other people who argue, no, it's good faith. They are only trying to stop it because North Korean hackers. You and I aren't going to get to the bottom of that. But it does bring the question of, it appears that the North Korean hacker argument is true. And rather than debate the accuracy of it, let's just hold that as true. Now, the counter argument is, well, Wells Fargo and JP Morgan and UBS, they seem to be doing a lot of, complicit activities that help people launder money. Whether they know it or not, it over and over and over again, we see from Mexican cartels to terrorists to, whoever, there's money going through those organizations, but we don't see the same heavy-handed approach. There's fines sometimes, there's whatever.
There are a lot of fines. I mean, like HSBC, I think, got hit with.
They're probably the big one.
Yeah, they're the big one. And it was pretty impactful, I think, for that bank. And, I think the distinction that some would make is that, well, yes, but all of these banks have very robust compliance regimes, departments, anti-money laundering protocols, and so long as they're making, the good faith effort, and they're checking all the boxes on the compliance checklist, then that's different than what we have here, because one, we have a group that's not doing that. Now, I think they did start to make some efforts at one point, the Tornado Cash entities, to screen OFAC sanctioned addresses.
Which feels like at the most elementary level, like that's like a pretty simple, fine will prevent the OFAC sanctioned addresses from interacting with it.
We can have a debate about whether or not, your privacy tools should be should be accessing blacklists. But yes, so they were attempting to do this, but at the same time, the other distinction is, well, banks, have a social economic purpose. Extend credit and just allow the economy to grow at a much faster rate than barter. Et cetera, et cetera.
Basically, that argument is like, yes, they're being treated differently, but there's a reason why.
A reason why, right? And because Tornado Cash, the purpose for Tornado Cash, it's a privacy enhancing tool, right? Some would say it's a money laundering tool. No. It's a privacy enhancing tool, and money launderers have used privacy enhancing aspects of it to their benefit and to the detriment of national security.
And this goes back to the whole encryption debate of you and I can message on, I'll use WhatsApp as the example. Plenty of people will pay the encryption there. But if we are communicating, it's not because we necessarily are hiding anything. It's actually, we just want the privacy to be able to communicate without, worrying about people hacking or communications or whatever. But the argument previously had been, no, this is only going, or bad people will use it.
Right.
And so just because bad people will use it doesn't mean that good people shouldn't have the ability to do it. Same thing with the bank, right? Bad people will use it doesn't mean good people shouldn't use it.
Right.
Which then brings us to Tornado Cash, which is like, if bad people use it, does that mean good people shouldn't use it?
And this is what a lot of people are struggling with, and I'm struggling with it too, is to figure out where the line is, right? Because if we start from first principles and say code is speech, you have a First Amendment right to code and to publish that code, then there should be very few, prior restraints on your ability to publish that code. Again, you can make these edge case hypotheticals where, you've got, dirty bomb plans and stuff like that, right? That are clear national security importance that, there might be some, but again, even in that case, if you're arguing from just first principles, this is we're still there's some social value to even discussion publishing dirty bomb plans, right?
I mean, because then
you can figure out how to diffuse the dirty bomb plans.
Yes, but this is like the whole ghost gun argument, right? Which is like, there's a lot of people who are like, hey, we don't want unregistered guns on the streets. We don't want all this stuff. And then there's a whole nother group of people who say, the plans are not the gun. And even if the plans increase the likelihood that somebody will create a quote unquote gun, but actually it's the receiver, it's not the full gun. Like there's all this nuance to that debate that we don't need to get into. The plans for a bomb and the plans for the lower receiver of a weapon still are protected. To some degree, right? And again, to some degree. If you're publishing it with an explicit call, everyone go make bombs and go blow up buildings,
right, then you're inciting violence, and then that's not protected by the First Amendment.
Correct. So there's context that goes into if you just publish something versus if you alongside say go incite violence. Okay, that's a little bit different. But with the Tornado Cash specific example, from again, I've read enough about it to understand it was always just, you can use this to enhance your privacy. It was not a call to, hey, every terrorist, criminal, and money launderer in the world, come use our tool because like it's a free for all now.
Yeah, as far as we know, publicly that was what was going on. Who knows who knows what's going on behind the scenes.
The details would change if all of a sudden the developers of Tornado Cash were emailing it to North Korean
all the assumptions we have now, and the publicly available information we have now, that's true. And so, you get into this because of where we are in our First Amendment precedent with functional aspects of code allowing incidental regulation of the speech elements. It is now the government gets to draw lines on how much usage is illicit before they're going to regulate the speech. So
like literally a percentage amount. Like if 1% or less, then they're okay.
This is obviously not the law, right? And this is not like the doctrine, but this is functionally, I think, this is a heuristic to look at it, right? This is a mental model to look at it. There was about 10%, it was 12% that was flagged of funds that went through Tornado Cash that was ransomware derived. Half of the funds were DeFi, were flagged as just DeFi funds, right? So when you look at the percentages of licit versus illicit use, and then I forget what the other categories were, the overwhelming amount was just general trade and commerce, right? Some would say speculation, but
Gambling.
That's also trade and commerce. Okay, so in that case, the government stepped in,
which is almost like you're hinting at, because we don't know the answer.
Yeah.
But like, let's say the government had an unofficial rule that once it crosses over 10%, once we hit double digits of illicit, use for
fund
flags,
flows,
now we will step in.
Right.
But if it had stayed at 9.5%, maybe they wouldn't have stepped in.
And it's like, well, is it percentage of, they were going by percentage of funds that were flowing through, but percentage of users, the North Korean hackers was a much smaller percentage of users. And so that's where, neutral tools, so you can say Tornado Cash is a neutral tool. It just allows privacy. Neutral tools can be used for good or for bad. The internet is used for good and bad. So, where you draw that line is the question. And right now the government has the pen and they get to draw the line. Now,
is that a good thing?
That the government has the pen?
Yes.
The government's got to have the pen to some degree. We do, if we want to live in a society that's,
has a government
and is safe and is protecting you from, foreign aggression, what have you, then you need to have a government that is drawing lines somewhere. But the way, how they use the pen with respect to Tornado Cash, I think was outside their statutory, OFAC statutory mandate. Because again, they drew the line by adding just pure unowned code. Those addresses that are on the Ethereum blockchain forever were sanctioned, but the authorizing statute doesn't give OFAC the ability to sanction unowned code.
So is this the equivalent?
This is not intellectual property of Tornado Cash. This is unowned code.
Is it the equivalent of, we said, okay, the unincorporated organization, right, or whatever, the group of people, okay, again, we can debate whether they should or should not have been.
It's an entity, they're
but it at least
authorized,
fits what they're allowed to put on the list.
It fits what they're statutorily allowed to do.
Those people have accounts.
Yep.
And so similar to a bank account, right, those get put on. Again, whether or not they should have been put on is different than they are allowed to be put on or there's precedent for being put on this list. But then you're saying it's almost like, these individuals read a book one time.
Right.
And now they don't own the book. So we're going to put the book on the list. And it's like, wait a second, like the book is a neutral thing.
If you go to the library and you pull the book, then you're going to be in violation. Yeah.
Yes. And that is where I think this First Amendment question comes in, which is just because these people who you deem to be in violation of something, and again, we'll debate whether that's true or not, they read this book, now no one else can read the book. And that seems to be where a lot of lawyers are saying, wait a second, we may need to have a deeper conversation about this.
Yeah.
How do you think that plays out?
Yeah, it's difficult to game out because it's code that's not owned by anyone. Going back to that question of like standing, who's been harmed and has the ability to bring a suit to challenge this OFAC action. It's difficult to identify anybody, right? So teeing up a court case, which I know Coin Center is trying to do, is really difficult. There's some argument to be had that Americans who used Tornado Cash and deposited into Tornado Cash and had not withdrawn funds from Tornado Cash and still have their funds locked in the protocol and are now look, I'm not giving anybody legal advice. But
none of this is legal
weary
advice.
about withdrawing that.
Yes.
Those folks might have a claim because their funds have essentially been frozen without prior
due process.
Without prior notice. So that's an avenue that if somebody wanted to challenge these this broader action, that would be, I think that's that would be a strong case.
So from a non-lawyer, a lot of times there's cases. Bernstein seems a little bit different, but maybe in the crypto world, there's an individual, I believe he was in Kentucky. He was taxed on, I think, staking rewards. And it was a pretty nominal amount. I mean, I think it was like $2,000 or $3,000, frankly. But it was more of a principled fight than it was the economically driven, hey, this is a lot of money. And he's continued to pursue that. There's a lot of folks who are watching because they're saying, hey, this is pretty important precedent.
That is an interesting case,
It feels like here...
Jared versus the U.S. or IRS,
It feels like here with the Tornado Cash, like there are probably people who have material amounts of money locked up, whatever that is to them. But it does feel like there's almost this like legal apparatus that is somebody is going to pick up the flag and take on this fight. And it's more of the principled fight than it is, hey, I sent $10,000 in and like, you know, that's my life savings.
No, but you do need some harm to be able to bring a case. The First Amendment is First Amendment challenges, it's a little bit easier. That like harm requirement is a little softer.
Okay.
Because the idea is you don't have to have suffered a direct harm if there's an argument that it's like overbroad and there's a chilling effect and it's preventing the public from engaging in that type of speech, then your direct harm requirement is there's a little more wiggle room there.
Okay. So then let's go to maybe the second step, which was there's this OFAC list, a bunch of stuff gets put on it. I think there was kind of a shot across the bow a little bit and the crypto community was like, oh shit, things just got ratcheted up, you know, a couple of notches. And of course, there are people on the internet who will take things into their own hands. And there's an individual who went and collected a bunch of publicly known or kind of doxed addresses.
Right. It was like Puma and
companies,
Shaq,
celebrities, well-known people in the crypto world. I mean, this was very much like, let me go to, you know, a whole list, get a bunch of these addresses. And then they began to withdraw very small amounts, I think it was 0.01 ETH, into these publicly known addresses.
Right.
So at the most kind of barbaric analysis, Puma, which is a legal, you know, a corporation that would like to be in good legal standing in the United States of America, and for everything that we understand, does not want to participate in any sort of money laundering or violation of the OFAC list. They potentially violated the OFAC list because they received funds that came from a entity / software and account,
sanctioned
whatever
piece of software,
that was sanctioned. Now, I would imagine, and again, you will correct me if I'm wrong here, if they went to court and said, we didn't do this, we didn't know, it's the equivalent of somebody sending me a wire, right? And I didn't ask them to do that. I just woke up one morning and it was sitting there. They probably won't get in trouble.
Right.
But I don't know. How do you analyze that?
That's where OFAC is like serious business because it's a strict liability regime where like the government doesn't have to prove intent.
Okay, so explain this a little bit more. Like, and maybe let's use Puma only because they are an entity. I don't want to pull individuals in. Puma, I apologize. Somebody else sponsored by them. Somebody else did this to you. But like, as a corporation, I think it's different than an individual as well, where it's like they have legal teams, they have compliance, like they have shareholders, like there's a lot of complexity. How would you begin to analyze, like, is Puma potentially liable for something here? Or do they just go to court and say like, hey guys, come on.
Right. Well, it would take, I mean, like practically speaking, OFAC is not, you know, Department of Justice is not going to bring an action against Puma for, you know, unknowingly accepting funds that came from Tornado Cash. But, you know, again, so going back to the strict liability, right? They could. It doesn't matter. It happened. You received the funds. So a legal scholar, he's a practicing attorney, but I'll call him a legal scholar because he predicted this a few years ago.
Really?
Yeah, Andrew Hinkes. He's an attorney at K&L Gates. He had predicted that like someone could, he called it like a spray attack. Right, could just spray this essentially tainted, you know, be it ETH or, you know, Bitcoins, out, and because in Ethereum and Bitcoin and most cryptocurrency, you don't have to accept it. Just it just shows up on the ledger as being in your address. So he had predicted this, and it's a big problem. It's a big problem because under the letter of the law, there's violations there, and so it's just. It goes back to kind of that boundless discretion of OFAC, right? It's just up to them now, like how they're going to treat all this. And
let's say that they were like, no, fuck you guys, you did this, and they wanted to enforce the letter of the law. What is the penalty? Or like, how bad could the penalty be?
Yeah, I mean, the penalty can be jail time for folks. So, it's real serious. Probably it would be like fines, but it can be jail time. There's criminal penalties. But I think there's a process and a procedure for like sequestering funds that you suspect are tainted and flagging it with OFAC and things like that. So I'm sure Puma's compliance folks have, checked all the boxes and, made sure to quarantine off any Tornado Cash ETH.
Well, so the reason I want to start with Puma is because they have all that infrastructure. Shack, I do not think has a full-fledged, compliance team.
Right.
And
I know you might be surprised. He's a pretty big business.
So I'm going to move from Puma to Shack
to whoever
the average
else.
citizen, right? And
Exactly.
I think that it's at least expected that Puma has some sort of legal, team and compliance team, et cetera. Shack's maybe in the middle, maybe not. The individual doesn't.
Right.
And so it almost goes back to this idea of like the banks, right? I remember reading this article at one point. One of the things that the banks do in order to kind of shield liability, or at least, again, you could argue whether it's good faith or it's kind of cover your ass, if there are transactions that they think could potentially be troublesome, they basically just flag them. But the problem is that they're incentivized.
Reports, suspicious activity reports.
They are incentivized to use these SARs or suspicious activity reports. Just do them all. Right? Like at some degree, like just keep processing all the transactions and then you just say they're all suspicious. Now, again, they don't do that, but they do a lot of them. And so if at some point...
on the side of caution, let's put it that way. Yeah.
It's a very politically correct way to say it. It's the err on the side of caution. And again, there's an argument as to like, maybe that's a good thing, right? But then if somebody shows up later, like OFAC or whoever, and says, hey, that one was problematic, they say, well, we flagged it, like we thought it was suspicious, and like we sent it to you guys, and whatever happened from there happened. The average individual doesn't have that infrastructure, doesn't even know some of this stuff exists, and you get into these problems. So I guess it becomes this weird thing where like now it's almost up to whether it's the Department of Justice or somebody, do they want to enforce the law or not? And that that kind of gray area feels like, again, where some legal folks are standing up and saying like, let's have a deeper conversation about this.
Absolutely.
This episode is brought to you by 8 Sleep. Good sleep is a game changer, and the 8 Sleep Pod is the best sleep machine. I sleep on it every single night. A great night of sleep allows you to be healthier, be more rested, and have more energy throughout the day. And on the brand new 8 Sleep Pod 3, you can sleep as cold as 55 degrees Fahrenheit or as hot as 110 degrees Fahrenheit. That's the secret of thermoregulation. Better sleep, better energy. Get yourself an 8 Sleep. You can go to 8sleep.com/pomp today to go ahead and get $150 off your order. 8sleep.com/pomp. Not only do I sleep on it every night, it literally changed my life, and I begged the founders to let me invest in the company. 8sleep.com/pomp. Go get yourself an 8 Sleep pod and get a better night of sleep.
Yeah, that's where it goes back to, there's got to be, especially when you're talking about speech, there's got to be some kind of guidance on agency discretion when they're licensing or preventing speech of some type. There's got to be just protocols that they follow, and then there's got to be a clear method for reviewing that. Now, on that point about a clear method to review it, someone whose funds are in Tornado Cash, there is a process whereby you can apply for a license from OFAC to remove funds or to transact with a sanctioned entity. So there is a process, but again, that's a post facto process. And when we're talking about due process, we're talking about, pre-notice. That's that's the gold standard of due process. That's
forget
what we want.
crypto for a second. If, I don't know, you were on the OFAC list, right? And I had previously had a business relationship with you had some money, I wanted to withdraw or get that money back. I could go and say, hey, here's all the details. Will you pre-approve me to do this transaction? I'm not trying to do anything nefarious. They approve it.
Yeah, there's a process for that.
Got it. Okay.
Yeah.
I can't imagine they're handing out a lot of those licenses at the moment.
No, I don't. I can't imagine anybody would want to dox themselves to apply for one of those licenses.
So this brings up another fascinating point, which is we have a piece of software which we will hold the assumption that it is decentralized, no one has control. I do think that will come into question, and it will be fascinating to see how decentralized is it actually. But many of the addresses who have been engaging with it or interfacing and transacting are not like, Anthony Pompliano's wallet address.
Right.
It is a random string of letters and numbers.
Yeah, they're still anonymous. Yeah.
And so I do wonder how far will legal organizations or government organizations go to figure out who are all those addresses.
Yeah.
Now, they've obviously done it for the ones that they claim to be money laundering or whatever. But, Joe Blow off the street who put $10 in because he wanted to test out the tool is just a random address today. Because it now is on the OFAC list, do we expect every single one of those accounts they'll do the work to dox
I don't
them?
think so. Okay. I don't think the incentive is there for OFAC or Department of Justice to do that because, again, they traced the Lazarus group. I think that was the North Korean groups. They traced the money into Tornado Cash, right? Because that's you got to start somewhere. You can't really. It would be difficult to. I mean, I guess there are ways you could trace it if you could map personal identifiable information onto coins essentially, or ETH that comes out of Tornado Cash after the fact. But yeah, I mean they were chasing the money laundering funds and the ransomware funds into Tornado
The funds
Cash.
led them to the tool, not let's start with the tool and then work backwards.
Exactly. And so again, because I forget who was Chain Analysis or one of those analytics firms has done done some heuristics and breakdowns and said half of it is DeFi. Presumably they know that there's not really they know generally what type of activity was going on in Tornado Cash. Again, they don't know who was doing what necessarily all the time. But yeah, I don't think the incentive is there for DOJ to go after every single user who's ever used Tornado Cash. But again, now we're having these conversations and we're having conversations again about privacy enhancing tools. And it really all comes back to, do we have a right to anonymity? And
how would you analyze
that
we
right? So when you're talking about speech, the Supreme Court has said you have a right to anonymous speech in certain circumstances, like when you are engaging in political assembly. So actually, and this is kind of what gives me a little bit of hope about where we're going with the First Amendment and code and anonymity and privacy. I think it was last year, a case called Bonta, Americans for Prosperity versus Bonta, came out. And the Supreme Court invalidated a California law or regulation that required disclosure of political donors' identity over a certain amount threshold.
Oh, interesting.
Yeah. And it was $5,000 or something like that. So major donors, all these PACs had to create a list and turn this list over to the California regulator who was regulating in election spending. And the Supreme Court struck that down, and based in part on this line of cases that you do have a right to anonymous speech and anonymous assembly, which stems from our rights to assemble anonymously when we were creating this nation, for fear of being hung by the British, right? So the right to anonymity is a deeply ingrained, I think, American value, and it's only really in recent times, modern times, where that the practical ability to maintain anonymity has been rolled back, right? So, so the Supreme Court is putting out opinions that respect and acknowledge that right of speech, and even so, this was in the context of spending too, right? This was in the context of keeping political donations anonymous.
Are electronic dollars, like if I go to the bank and I send you a wire, is that considered speech because it's software?
Is it considered speech because it's software?
Like I'm not sending you physical dollars.
Right. That is a metaphysical question that has not been resolved in the courts. So this gets into if I was going to give you a physical dollar, that's kind of like conduct.
Yes.
But it's also speech, if I'm giving you that money to support your, campaign for mayor of Miami or whatever.
That'll never happen. I'll let Suarez keep doing his thing.
Yeah. But, I'm of the opinion, and not a lot of legal scholars agree with this, but I think a lot of people in the cryptocurrency and Bitcoin industry would agree with this, is that money and transacting is a form of speech. It might be more conduct than speech, but it transmits information because what's that phrase? Like, don't tell me what you think, show me your investment portfolio, right? Like, what do you value in life? Where, and what is more expressive than me showing you where I prefer to spend my hard-earned, time and effort, right? Money is just like the store of all of your prior work and effort and blood and sweat and tears, right? So when I show you what I'm going to spend that on, that tells you a lot about me, right? I think there are a lot of communicative elements to transactions.
Well, I'll take it even a step further of just like, if money is not in the analog form, right? It's not physical money, and I send you a wire, it's all software.
Yeah.
I'm sending you words in a database, right? And now, sure, they have purpose, they have value assigned to them, they have all these different things. But I communicated with the bank. Literally, I told the computer, do this. The computer then sent you words. Your bank accepted those words and put them in a database for you to look at later.
Right.
And in some way, it's words.
Yeah, it is. And it always goes, money also is like this giant accounting system, right? It's how society directs where to place, its efforts and its capital so that we can progress. And so that it's a giant information system, all forms of money. Even before you had, I heard this explanation of what credit was the other day from a podcaster, and he describes it as just at its base level, two cavemen in the cave, and you make fire today, I make fire tomorrow. That's a credit transaction, right? Speech, right? That's speech. That's not, there was some work that occurred, at different times, and there was value that was exchanged with, the work that was done to make the fire, but it was all just speech. That credit formation was just speech. I'm not going to take credit, no pun intended for that analogy, because it was really good. It was the guy from the Crypto Voices podcast.
Yeah, he's very good.
Yeah.
If we go back to Tornado Cash, the next step in this kind of analysis is, so we have the OFAC stuff, then we've got the like spray attack. One of the developers gets arrested.
Yeah, in the
not in the United
right?
States. How do you analyze the arrest itself, the fact that it didn't happen in the U.S.? I don't know if he was an American citizen or not.
I do not know.
Okay.
I don't know if he was a citizen.
Okay.
Yeah.
But just the arrest in general, how do we understand the legalities of it or the precedent it sets?
Yeah, I mean, it's a big chilling effect. It sets a huge precedent that, if you're You're coding and launching and publishing privacy-enhancing tools that then money launderers go and use that you could be liable, I guess. Now, again, we don't know all the facts behind that. Who knows? Maybe, you know, I don't want to hope for criminality, but I hope there's more of a tie than just the fact that this guy in this group wrote this code and published this code. I would hope there's more details that we don't know.
There are details that could come out, which we are not privy to today. I don't think anyone in the public is, that would drastically change the analysis. But given the information we have right now, it appears that there's not nefarious, malicious conduct or anything, and that's why there's so many questions. Yeah, and it really has created a chilling effect. I mean, anyone who is an engineer and a software developer is scared. I mean, they're scared, and understandably so. I mean, it is, you know, it's like we're thrust back into the 90s, and you know, you've got Goliath, you've got, you know, the governments coming down on developers, and that's a scary thing. And we as a society shouldn't tolerate it. We should, you know, raise our voices and say this is not consistent with our values as a country and a nation, and, you know, not consistent with our Constitution. We don't want to live in a society where anonymity is criminalized. We want to live in a society where, you know, privacy and anonymity are seen for what they are, which is protection, right? Protection from, you know, those who might want to, you know, steal our identities, you know, steal our funds, those who might want to harm us if we have the wrong political opinion, which thankfully in the U.S. is not, you know, always the case. Certainly the government is not always trying to harm us because of our political opinion. But in most of the world, that's not the case. And so we should be promoting these tools and as a society and trying to reclaim our rights to anonymous speech and anonymous assembly, and the ability to go throughout our lives with the authority and the autonomy and the power to choose what information we disclose to others, because that's what privacy is. You know, there's been tons of definitions of privacy over the years, and everyone struggles to understand what it is. Justice Brandeis wrote a law review article back in like the 20s that was like the foundation for our understanding of privacy, where he said it's the right to be left alone. It is, but I think the cypherpunks helped us realize that privacy is really the right to let other people know what you want them to know, and that you maintain control over your information. And it's that control over your information that is the key to privacy. It feels like the OFAC list stuff, a lot of people, wow, like that surprised and shocked people. The arrest of the developer, I think, ratcheted it up even more. Yeah. And again, we don't have all the details, but how do they draw the line in terms of the privacy technology? And I'll give you maybe kind of different ends of the spectrum. So if I was a software developer who worked at, I don't know, Coinbase, a publicly traded business that for all intents and purposes follows the rules, you know, has a compliance team, legal team, regulators have signed off, it's in the public markets, all that stuff. And I am creating technology that enhances the privacy of our users to be able to transact. And then you've got, you know, maybe Tornado Cash on the other end of the spectrum. Not saying that either one is right or wrong or whatever, but just like, how do they think about, like, is it all privacy technology? Is it just ones where somebody does something bad? Unfortunately, I am sure that somebody has used Coinbase to do something nefarious or wrong. And so, like, how do they think through that? Or is it literally just kind of a group of people that get together and they decide the severity, and then later on the courts figure out whether it was the right decision or not? Yeah. I mean, again, I think it comes back to, you know, the government does have, you know, it doesn't have boundless resources. We think it does. It has a lot, but they still do have to, you know, Department of Justice and OFAC and these
these departments have to pick and choose what they're gonna, who they're gonna go after. And so, again, I think it just comes down to the most nefarious characters are going to, go down first.
It's what we've seen with the SEC regulation.
Right. The low hanging fruit. And in the process, right, they're taking a swing at privacy tools.
If we had a third person here on the podcast and they were from the Department of Justice or from the Treasury or whatever, what are some of the questions that you would have to better understand the situation? Like, are there things that you're like, man, these are like the 2 or 3 open questions right now that maybe it'll be decided in court, maybe we'll get more information, but these are the things that you're most interested in learning more about around this specific case?
Yeah, I mean, it would, first and foremost, it would be, and this is the question we should all be asking whenever there's any government action anywhere, state or local or federal, what's your authority for this? Where do you derive the power for this action? Like we were talking about before. So I would like to get some understanding of their thought process for putting these smart contracts that no one owns on the list. Whose property is that? Are these aliases for someone? What's the rationale behind that? Because I think, perhaps there's not an understanding from OFAC of the engineering behind this system. And maybe there is. I mean, it's a lot of smart people.
Well, and I think it brings up the question of, like, again, decentralization. Like, how decentralized is it? And we've heard from the securities regulators and others. Was it DINO? The terminology, right? Decentralized in name only. I think most people who have looked at the Tornado Cash situation, people way smarter than me who are much more technical and read the code and stuff, they do believe that it has legitimate claims to decentralization.
Right.
Now, decentralization is a spectrum, this whole thing of like, is it, you need 10 nodes, you need 50 nodes, you need, a certain amount of people holding the keys. Like there's so many different ways you could cut it. But it does feel like a lot of people think it checks those boxes.
And those are some questions that we could ask, right? Like what is the rubric internally that you're using to determine, control over this tool? Admin keys, or however many developers are working on it, and who's directing flow of funds. The developers weren't directing the flow of funds through this protocol. So
it's fascinating to think about also because it begs the question that regulators, governments, organizations that have oversight in various parts of economies, I think most of them, and I've talked to some of these individuals, everything from, SEC commissioners to the head of CFTC, also, they're like, look, we got a pretty good grasp of like some basic stuff, but we're figuring it out along with everybody else, because guess what? A piece of technology that exists today didn't exist 2 years ago. Right? And like, as this thing's getting built, the builders and investors are figuring it out, but also the regulators are kind of running side by side trying to figure it out. And just naturally, the innovators will always be out in front, and then the regulators kind of catch up as they go. So I think anyone who analyzes this stuff, you have to like put in one part of the conversation of like, if you were the regulator, would you have all the information necessarily to make an analysis? Some situations, yes. Other situations, no. And I think that's an important distinction. But the second piece of it is there's a lot of information that we don't have in Tornado Cash situation, but many others, where what's being publicly presented, if you hold it at face value, you come to one analysis. And then we've later found out all sorts of different pieces of data that you're just like, if I'd known that other data point, like my mind would have completely changed. And so I think that there's a little bit of like the fact-finding mission that some of these bodies are going through, of just like, how do we understand the full playing field before we start making decisions or frameworks or rubrics or whatever? And I don't know if there's right answers, right? Like sometimes there is definitely a right answer.
Right. And from the regulator's perspective and, OFAC and DOJ's perspective, like the FBI's perspective, if they wait, this would be the argument, to let it all play out and to have it figured out, then these tools are going to be in the hands of every bad guy, and every bad guy is going to be using it, and it's going to be it's too late to do anything about it. And some of that is just, the answer to that is we have to tolerate some criminality in our society. You can't, look, we've been having these debates, since the 90s, but, definitely since 9/11 and the Patriot Act, Americans have been struggling with the trade-offs between safety and civil liberties and privacy. And this is just another front in that continuing discussion or battle, if you want to call it that.
How do you think we're doing in that balance now? Like, would you give us a A+, F-? It obviously each situation is a little bit different, right? Like TSA and all that people get all worked up about. But like, do we do a pretty good job? Do we do compared to like other countries? Are we actually like really shitty? Like, how do you think of it?
Well, if it's a comparison game, I think we're doing okay. I would give us a C. Okay. Just because I feel like our ability to challenge actions in the courts is still pretty strong. Our as much we're talking about free speech in the First Amendment. We still have a First Amendment. It's still there and it exists, and we point to it and we can argue over it, and it is enforced. That's not the case in a lot of the world. So I feel good about that, Now, I think, and this is just since the Patriot Act and 9/11, we've gone backwards in our rights and civil liberties and our freedoms. And again, it was understandable at the time, the fear that the country felt, and but then we had too much of a counter response domestically, internationally as well. I mean, it's kind of wild because we're about the same age, and so like
both 21.
Yeah, exactly. Our adult lives, we've been living in the Govt, in the global war on terror, right? I mean, it's something that, but we're old enough to have remembered like the before times, in the 90s, and it, how it felt different. Even as kids, I it just felt a little bit like freer in terms of, I don't know.
Walk to the gate.
There was at the
airport.
Exactly.
Like you pick up somebody.
You pick up your family at the you go back and you watch Seinfeld or Friends on Netflix, and you just like, it's a time capsule. And it sometimes it hurts because you're like, wow, that was like, it wasn't all bad. Like, we didn't have planes falling out of the sky every other day. Like, and this is this debate about like safety and the trade-offs between safety and civil liberties. I had a German professor in college, and this was early-ish in the war on terror, and everything was still fresh. And she was saying, look, Germany went through this. Germany had I guess in the 70s, series of terrorist organizations and attacks. And she said, look, we had to decide, like, do we want to lock ourselves down and live in fear, and give up all of our liberties for safety, or perceived safety, I guess, or are we going to hold our heads high and live our lives without fear, and treating everybody with dignity and respect, and keeping our rights? And she was of the opinion that Germany at the time had made the right choice and chose not to aggressively shut society down to combat terrorism. And America went in a different direction. We did, and it's a shame. But again, it gives me hope because we have tools like Bitcoin that do provide financial freedom. Then we have tools like cryptography, and those tools are enhancing our safety and our through anonymity, while at the same time they can be used for ill. But I think those tools are in everyone's hands, and so we've got the ability to keep moving forward and reclaiming freedom.
So I met you because you were on Peter McCormick's podcast.
That's right. Yeah.
A shitty podcast, but good podcast. I love Peter. And you were talking about Bitcoin, and what Bitcoin, the first question that came to mind when I saw the Tornado Cash stuff was, if I was a government official and I was hell-bent on just completely stomping out Bitcoin, and I was based in America, could they do what they did to Tornado Cash and just say the entire Bitcoin blockchain is now on the OFAC list and anyone who touches it?
I mean, theoretically they could, right? Theoretically they could.
Like, I've never heard anyone talk about that.
No. But yeah.
You and every other lawyer would be lined up outside the court ready to like have a field day.
Exactly.
But it does open up
No, it opens up this is an attack vector for any protocol. And so every protocol and all developers working on these systems, communication systems for transferring value or just communication systems in general, should be rigorously testing and having really serious conversations about whether or not their technologies are sufficiently decentralized to survive something like that. Bitcoin will survive something like that. It'd make it difficult for us in the States to transact, but it would survive.
The technology and infrastructure would survive.
Yeah.
The U.S. user could be quote unquote frozen out, right from this. What it then brings into is this whole thing, like, decentralization is really freaking important.
It's really important, right?
But just because you have the decentralization, that protects the protocol. That protects the tech itself.
Right.
It doesn't necessarily have the same impact on the individuals because they are still subject to being individual citizens.
And this is where you need base layer privacy and base layer anonymity. And Bitcoin's doesn't score great on that. There are tools you can use that are similar to mixers but are different. Coin join tools and things like that, where you can obscure and regain, forward anonymity in your transactions. And those types of tools are desperately needed because that's the piece, like you said, that's going to allow individuals to continue to use a decentralized network. There are privacy coins and privacy protocols that have that built at the base layer, and they make different trade-offs that Bitcoin's made. But that's the key. That's what's needed is privacy and anonymity. And the problem is we live in this, Bank Secrecy Act regime where there's know your customer regulations, and it's really hard to participate in these protocols, these cryptocurrency digital asset protocols, without going through these KYC processes and these KYC gates now. Like, it's really difficult. You can do it, but it's not user friendly. And that's where, and I'm not an engineer. If I were, that's what I'd be working on. I'd be working on, those privacy tools, anonymity tools that, help us and help individuals participate in these protocols anonymously.
When you think of Bitcoin, it has the ability, right? If people continue to build technologies to do a whole bunch of things that I think the Bitcoin community is very excited about. One of the things you've looked at, which I find fascinating, is Bitcoin today in its current form, without having to be built kind of further or continued innovation, can really, mitigate some negative externalities. And one of the things that I saw that you wrote that fascinated me is, in many legal cases, there is a judgment. And if there are financial penalties or fines, through a whole host of different actions, the court essentially can take the money. They can freeze assets. They can confiscate it right out of somebody's bank account. The IRS does this time to time. Somebody owes back taxes or whatever. The idea of self-custody changes the playing field there.
It does, yeah.
How does that now enter into the fray of just like, if they can't freeze your assets or they can't confiscate your assets, does that level the playing field? Does that ratchet up their scrutiny of, hey, we don't like this?
Yeah, so that's Bitcoin is a, seizure resistant, it's not seizure proof, and censorship resistant money And if you self-custody it, it's not like having a bank account that can get frozen, right? So what happens in the how it affects the legal system? This is something I've been thinking about, because this is predominantly what I do is, I work on litigation, but I'm an appellate attorney, so I see the cases after there's an order that needs to be appealed and overturned or upheld. And then sometimes we get into these like post-judgment collection issues. And sometimes they're pre-judgment, where somebody is being forced to turn over money before there's even a determination of liability.
Why would they do that?
Yeah, exactly. So this is very important, because in the United States, pre-judgment attachments are really hard to get. They're frowned upon by the court system, because if you have your property and you haven't been determined liable, it's still your property. If ownership hasn't been determined by the court, we're not going to take property that's probably yours, maybe not, but it's in your possession. Possession is 9/10 of the law. I'm going to let you keep that property until there's a determination. That's not the case in a lot of countries. So we saw this in Canada with the trucker rally, and there was a big movement, a lot of donations through Bitcoin to fund that political protest. And then there was actually a civil class action lawsuit by like the Ottawa businesses who were saying that they lost revenue from this, and they sued the organizers of the trucker rally. And one of the Bitcoin for the truckers organizers was a defendant and had to turn over all the Bitcoin that they flagged as his, so that it wouldn't be dissipated and disappear before there could be a collection. So that's the theory.
It's almost like a flight risk.
It is. It's like that. Now, in that case, this is something called a Mariva injunction. Like the common law jurisdictions have this. It came from England. Canada has it. I'm sure like Australia, and it's spread out. And it's used, to prevent dissipating and shielding capital that can eventually be used to satisfy a money judgment, which then, metes out justice between the parties.
I don't know how important the distinction is. I feel like I'm going to get a law degree here. But is it different than freezing assets? So like I think of freezing assets as like it's in your bank account and they say, hey, you're not allowed to move it, and maybe the bank helps them or whatever. This sounds more like we're scared you're going to move it, or we think there's a threat that you're going to move it. Give it to us.
Yeah, I think in that case, perhaps it would have had to been transferred, because the nature of Bitcoin is like, if you remember your seed phrase, like, you could give them, your wallets or whatever, but then, you'd just go spin up another wallet with your seed phrase and move it. So they probably, the authorities, somebody had to take custody of it. But usually when you're talking about bank accounts, it's just a freeze. And this is where, this is the difference between Bitcoin and the traditional financial system when it comes to money judgments. All of our financial system is built on intermediaries, banks, custodians, and Bitcoin allows for self-custody and disintermediates. And the way that money judgments are executed and collected is writs of garnishment on those third-party custodians. You have a bank account, I tag you with a judgment because whatever, you hit me with your car, simple tort claim or whatever, and you owe me money, and you don't pay it. So then I get a writ of garnishment from the court, and it's served on your bank, and your bank says, that's a valid writ, and here's the money. I'm going to remit it to you, Mr. Plaintiff. With a Bitcoin system where everyone's holding their own keys and has their own, their own wallets, there's no one to serve that writ of garnishment on to collect from. So now, the question is what do courts do about that? Obviously right now it's not a huge issue, but if we're going to talk in like a hyper Bitcoinized world, and intermediaries are gone, what do the courts do? And I think the tools they have available are these pre-judgment type attacks where maybe if they know that an individual has funds because, they have KYC'd funds and all of their information is on the blockchain and they can, follow the funds around, they can then get orders to freeze that money. Now, again, I have the keys, so who's going to freeze it? That's where the second piece comes in, where the courts have contempt powers, where they can hold individuals in contempt and put them in jail for not complying with court orders. So then if I get an order to turn over my private keys and I refuse, and the only place they are in my head, then the only recourse left for the courts is to start imprisoning people. And now I literally have the key to the jail cell in my head.
So this brings an even kind of more complex piece of everyone that I know who has done any self-custody.
Right.
When they first started, like, I've forgotten things, right? Or I lost something, or I sent whatever, right? And, thankfully for me, up until this point, let me knock on wood, it's always been, non-material amounts I was screwing around or whatever and learning. But there are definitely people who, on one extreme, the guy who's digging through the landfill trying to find a hard drive, but supposedly he's got hundreds of millions of dollars, but he literally can't find it. To maybe the people who joke on Twitter and say, oh, I got in a boating accident, right? How do they determine whether you actually forgot it versus you won't hand it over? Like
that's just going to come down to, putting the contemnor, possible contemnor on the stand, asking them questions, and then making that credibility determination there in court. I mean, this is,
that is crazy.
It is crazy. It's and it's something that it sounds far-fetced, but, it's happening. I'm tracking cases where this is happening. There was a case I can't remember what was in the States, but somebody, the plaintiff accused somebody of defrauding them out of Bitcoin and some other cryptocurrencies. They were in some business deal and the defendant never paid. And so I guess they were in the Netherlands maybe. So the plaintiff gets one of these pre-judgment attachments in the Netherlands. Wouldn't have been able to get that in the States. It's very hard to get those. Wouldn't have been able to get that in the States. Comes to the States and what domesticates is what it's called, that judgment. And so, our courts generally give credit and full faith and credit to foreign judgments that look like they're on the up and up, right?
Not from
you can challenge them.
Not from
North Korea, right? You can challenge them and say there was, your due process was violated in that proceeding. So this judgment gets domesticated, turn over the Bitcoin, and U.S. Marshals actually came to this defendant's house to ask him for the private keys, and he gave him the finger. I mean, figuratively, and didn't turn it over. And so this guy is going through contempt proceedings now in federal court for not turning over. I don't know anything about the facts of the case. I don't know, whether or not the allegations are true. But that is an instance where the court is going through contempt proceedings because someone is not turning over private keys.
So 15, 20 years ago, pre-Bitcoin, the only thing I could think of that is anywhat similar would be like if I had some massive safe, right, in my apartment or something, and I had a bunch of cash, and they came and they said, "Give us the code," and you're like, "I'm not giving you the code."
Exactly. Yeah.
They probably would just take the safe and like break it open, or whatever. Like there was still some path, even if you wanted to make it harder for them. This is that on steroids, right?
That on steroids,
and it feels very different. Today's episode is brought to you by FTX US. They're a safe, regulated way to buy Bitcoin and cryptocurrencies. They've got very cheap fees, sometimes as much as 85% cheaper than their competitors. There's also no minimum fees, there's no withdrawal fees, or any other hidden fees. Ultimately, FTX US is trying to make it dead simple for you to buy Bitcoin and cryptocurrencies. They also now have digital stock trading as well, with no transaction fees and no payment for order flow. All you have to do is go download the FTX app today from the App Store and use code POMP, and you'll get some money back every single time you trade $10 or more. Again, go download the FTX app today, use code POMP, and every time you trade $10 or more, they'll go ahead and they'll give you some crypto back. The more you trade, the more you earn. Download the FTX app today.
Yeah. So now if we're, proponents of this technology, we have to acknowledge that this is an externality that for an individual who's being wrongfully sued is great, that I can protect my funds. I had, I've told this story before, but I had a client whose father's gold coins that she was bequeathed and kept in a safety deposit box were seized to satisfy her husband's judgment in a case where she wasn't a defendant and he wasn't even an account holder on the box, but he had access to the box. And so the courts basically inferred, that, he had access and it belonged to him and those coins could be used to satisfy. So for someone like that who wants to store value and not have it seized under the color of law, because it happens, it's great. The flip side is, though, the money judgment transfer of value to administer justice is like a really important thing to society, right? Before we had this system, it was just go to the king and he's going to tell you, what the judgment is, right? And like, or it just goes back to like, I have to resolve my disputes through conflict because there's no other way, right? This money judgments are a very like, safe, orderly, they generally give process to everyone to have facts determined. And if you're now going to remove that linchpin from the justice system of being able to satisfy money judgments through, garnishment on intermediaries, where you have recalcitrant defendants, it has the possibility to stymie justice and to prevent justice. So that's an externality that we as proponents of this technology need to acknowledge and realize, like, Bitcoin doesn't fix everything, fix a lot of things, can also break some things in the process. I think, the society we eventually get to with mass adoption is on the whole better, but there's a lot of growing pains between now and then. And so we should think about those negative externalities and how to maybe avoid them and how we can facilitate systems that can accommodate, that help us get on the right path to our, where we're going.
Yeah, that makes a lot of sense. And you could see good and bad coming out of that, right?
Yeah, and again, it goes back to that neutral technology that's being used for good and bad.
I got a question on Twitter. I've already told you this question because I want you to look it up first. Let me put a big caveat on this. Is I don't know the individual. They were, I'm pretty sure it was a pseudonymous account, and they DM'd me and they said right after the Alex Jones judgment, and they basically said, this opens a can of worms. This is insane. If somebody can hold a media publisher liable for saying something that they actually do not believe to be true, then their words, not mine, essentially was, well, then every media company on earth, should be held liable, and explicitly pointed to, I believe he mentioned the Hunter Biden laptop story of like somebody who was publishing it may have thought it was really real, but they were saying it wasn't or whatever. So crazy characters involved, lots of complexity. But if we just pull out of this for a second, what was interesting to me, and I didn't want to engage too much because I didn't know who this person was, and like I was like, I have no idea. But what was fascinating was this idea of free speech. But there's an element of like publisher versus private individual, and then the moving of belief. And what I mean by that is like if somebody says something and believes it to be true and they say it, and they keep repeating it, but at some point they change their mind, then it feels like then they could become liable, which, however that plays out. But like, how do you analyze the Alex Jones kind of entire judgment with mainstream media and at least the perception, I think, from the average American being like, oh, they're lying to us.
Right.
Whether that's true or not, it could be debated. But like, has the game shifted now a little bit after this, or is this just implementing old rules?
I think what's interesting about I guess it's not interesting, but the Alex Jones judgment is he actually defaulted on liability. So
explain what that means.
So whether or not he was, the court essentially adjudicated him liable without him defending, because I think he was like dragging his feet on a lot of discovery issues and didn't turn over a ton of evidence and was just stonewalling for years and years. And eventually courts get fed up with that because it is an obstruction of justice essentially. And they will default you, meaning you're now liable. Liability is determined. Now we just have to decide how much you owe. So he essentially forfeited his right to defend himself.
Interesting.
on defamation.
So from a legal proceeding standpoint, they made a claim. He could have defended himself and maybe been victorious or not.
Right.
But he just decided for whatever reason not to do that.
Right. He was just stonewalling. So, that's an interesting caveat to whenever we're comparing this, this case to anything else, is that liability was a foregone conclusion based on Alex Jones's actions within the litigation.
Okay.
Now, in terms of like just general defamation law, right? I mean, there's a few, truth is a defense to defamation. If, opinion speech is a, defense to defamation, because that again gets into free speech, right? Something that's, if I call you a, shitcoiner, that's my opinion. It's not, I'm not calling you that. So that's another defense that could have been raised. Again, the allegations and, the statements that were made were really tough statements, right? That he was making about these parents of,
because it wasn't just about the event. I think it was also about individuals themselves.
It was about individuals themselves.
Said, hey, now you're talking about us.
Right. And attacking them when they went on, and gave interviews on television as crisis actors and things like that. That would have been really hard to defend. If I'm part of his defense team, that's because truth is a defense. So what, you're going to try and, prove that this person was an actor. You're not going to do that. That was a lie. Right.
So his situation, has a lot of emotions attached to it, which, right. But if we kind of pull away from the emotions and we just look at it, if he had showed up to court and not stonewalled or whatever, and he just been like, that was my opinion, does that absolve him and he could have said whatever he wanted it because it was quote unquote his opinion? Or how does the court look at opinion versus I don't care what your opinion is, you can't say certain things? Yeah, there's, again, it gets into, it's a really gray area when you go into that opinion. Interesting.
Calling someone a crisis actor, it seems qualitatively different than calling someone an asshole. Right. You're because now what you're doing is there's this concept in defamation law of the reason that you're being harmed is because your status in the community is being denigrated by that, presumed fact, that statement that's being offered as a fact. So yeah, it would have been it would have been. He was in a tough situation. He was in a tough situation. He would have been on the hook. He put himself in a situation. Yeah, he did. But let's be clear. Let's be clear. If I were on his defense team, I would have been in a tough situation.
I talk about a lot of crazy stuff on this podcast. I always got to make sure people understand that I am in no way defending anyone's actions. I'm just simply trying to understand what some of the details are. If we take that a step further and we say to ourselves, okay, one of the things that you always hear, and I think actually Elon Musk tweeted about this a couple of weeks ago. He was like, "Oh, it's really hard for public figures or people that are in the news or whatever to prove this defamation stuff." And it was around the article about him sleeping with Sergey Brin's wife. Right? Yeah. And he was like, "Well, she's not a public figure. Maybe she could go after them, but basically, I can't."
Right. He's a public figure. Yeah.
How do they determine that in the sense of if the parents in this situation, who I think, as far as I think everyone would analyze, are not public figures,
right?
But then they go on television and they're doing interviews on national television. How does a court look at what becomes a public figure?
I actually don't know the answer to that question. That's a good question. I actually don't know the answer to that. It would probably, I'm sure that it's going to be case law dependent on whatever jurisdiction you're in, but it's probably going to be looking at just general general press coverage of somebody, like
do you just walk out on the street and ask 100 people and if 51 or more know, then you're a public figure?
Yeah, that's a good question. I don't really answer that one.
The reason why I think of it is it's separate from that case. It's almost like, A-list celebrity, like definitely public figure, like D-list celebrity, maybe not.
And this does get litigated. Like there is case law out there on this, like who's a public figure, because that's one defense is like, oh no, that plaintiff is a public figure. So, the standard is
game on.
Yeah, it's like game on. Yeah. So yeah, that's an interesting one.
And if we go back to the question this person asked me, in terms of like the mainstream media, they have legal teams, they have compliance, they've got all this stuff that they're trying to do things the right way, hopefully. Could they be held liable? Like if they wrote an article saying something and somebody else at the organization didn't believe that thing, is that like a legal liability?
It can be. It's really difficult because you have to, it can't really be an oops, right? It can't be like, the investigative team, did its diligence, put out this piece, and then come to find out there was additional information that we learned after the fact, and then now probably newspaper has to retract at that point, maybe. There's actually a really good movie about this set in Miami with Paul Newman, Absence of Malice.
Oh, I've not seen that.
Yeah, you should go check it out because it's a great time capsule of Miami in like the 70s. And you look at, it's shot like on location here. And so like, he's living like in the bay downtown on a boat. And like, there's nothing around, right? It's just totally wide open. But yeah, there was a movie about this, and like, Sally Fields was a reporter and like reported on like, I guess his relationship to like the mob or something like that, which turned out not to be true. And like, it's an interesting movie. And it's called Absence of Malice because, that is part of what you're looking at in defamation cases when you're going after a public figure or whatever. You've got to prove, or malice is actually what you don't have to prove as a public figure, right? It's just the public figure. Actually, I think I've got that backwards. But anyways, it's a good movie. Go check out Absence of Malice.
And when we think about the public conversation, right? Media publishers are one piece of it. Celebrities, whatever, another piece. But we talk on Twitter. There's, hundreds of millions of other people on Twitter. Yeah. You've got all the other social networks or whatever. One of the things to me that feels the big question mark in society is how comfortable is society with those platforms moderating speech.
Right.
And I think most people, again, not everyone, but most people would say, hey, if you go on Twitter and you're like, I'm going to go shoot something, conduct a shooting or whatever, people are like, that shouldn't be on. And by the way, like law enforcement should probably be given a heads up and kind of addressed. If you go on and in March of 2020, you say, I think that this thing may have come from a lab.
Right.
At the time, no bueno, right? Literally people were kicked off, like all this stuff. Now, there's politicians going on national television talking about it, right? And so if we just zoom out for a second and with the benefit of hindsight, we say to ourselves, oh, facts can change. Right? Like literally, quote unquote, truth changes based on the information we have at the time. You can also look at CDC. At one point said masks don't work. Then they say they work. Now the new guidance kind of is like, everyone's good. Like, it's over. How do lawyers, courts, platforms think about like what's true in one moment in time may actually not be the like consensus truth at another time?
Right. Yeah, I think your example of like, someone going, making threats and threatening speech and inciting violence, that's a pretty good like line in the sand for a platform. Like,
yes,
we're gonna make sure that that's not part of our terms of service, and we're gonna moderate that content. Content moderation is not. I'm of the opinion that there's too much content moderation going on. There needs to be more of a free hand when it comes to speech. At the same time, these are private companies that are running these platforms, and they can moderate how they choose to. That gets difficult. That's where there's a lot of pushback from people, because it's like, well, no, they should be treated as common carriers, like, they're just the telephone wires now of our society. They should be regulated like a utility, and then we could tweak that. Now, the problem with that is, like, you're going to regulate Twitter like a utility. Well, who's doing the regulating, right? Like, now you've just given the government the ability to tweak what the content moderation is.
What does the government
does anybody
do?
really want that? I mean, some people might, but
Yeah. Oh, a lot of people actually in a scary way.
Yeah.
What does the government do with the telephones? Do they give them, like, again, uneducated view of it would be, I can call you and say whatever I want. And the telephone isn't gonna all of a sudden shut down, or my phone doesn't blow up in my hand. Like there's nothing kind of crazy that happens. Yeah, but maybe that's not true. I don't know.
Yeah, telephones. There's like wire fraud and stuff. If you commit crimes over the telephone, it's interstate wire fraud and stuff like that. But
it's all after the fact and goes to court.
Right.
It's not like all of a sudden that like AT&T or Verizon can't show up and be like, we're shutting down your service before you've gone to court.
Yeah. Think of it more, the analogy is, I guess, to like to broadcasters in the airwaves and stuff like that, and regulation of that. I'm not like a regulatory expert when it comes to that.
Neither am I.
I know there is some the First Amendment does prevent what the government can do to some degree when it comes to allowing counterpoints to be broadcast but so the First Amendment still backstops what can and can't be regulated there, but I'm not sure folks who say they want regulation around Twitter and these platforms, I think they need to think through a little bit more carefully, what that's going to mean. And if it's just that you don't like being, you don't like the way a platform is preventing a certain conversation from happening. Again, I want to reiterate, like, you really won't like it if the government's doing that. I mean, it's now, one can argue, well, they essentially are captured by the government already. They don't want to run afoul of the government because they're huge, giant, centralized corporations that are easy targets for regulation and antitrust, which is, what's going on. A lot of noise on the Hill about antitrust regulation and breaking up these big tech giants again. Yeah. So
I don't know how true this is, but I saw a screenshot, which again, I hope it wasn't fabricated. There was a screenshot where, are you familiar with this guy, Alex Bernstein? I think is how you say his name.
Sounds familiar.
He was one of probably the loudest voice questioning the response to COVID.
Okay.
At least one of them. And the screenshot was notes or communication inside of Twitter after they had visited some politicians in Washington, D.C., and it was, and I'm paraphrasing, but basically something to the effect of like, meeting went well. Their main sticking point was like they were asking why Alex Bernstein hasn't been kicked off Twitter yet. And so it kind of shocked me a little bit. Like, you don't get to see these communications every day. Obviously, there was some lawsuit or something where they probably made public. But that was like a question like, hold on a second here. Like, we have a government official, and it was unclear who government or whatever. But somebody in the government, apparatus asking a private company about it. Now, what didn't appear to be the claim was they were demanding kick them off explicitly. Right. Implicitly, right? If you're asking about one of the 330 million people who happen to use the service, or whatever the numbers are, how does that play? Like, right? Is that's normal? I don't know, but that's an example of like, well, maybe if it were all out, in, the regulation were all out in the open, it would be better than this backdoor regulation that may or may not be going on. I mean, look, we know there's a lot of interfacing
back channel interfacing that happens. I don't know. It's a huge, I don't have the answers. It's a huge issue. Society needs to be able to communicate freely with each other. At the same time, companies should be allowed to make decisions, for themselves. I mean, that's actually, there's a case going on here in Florida right now with the anti-woke legislation that was passed, where a judge, I think it was maybe in the Northern District of Florida, but here a federal judge here in Florida enjoined part of the legislation that prevented private companies here in Florida from requiring DEI trainings, diversity, equity, inclusion trainings.
So the government said you cannot require this.
Yes, the state of Florida said, here's a list of essentially viewpoints that were essentially white fragility type talking points that you are not allowed to make it a requirement. That
doesn't mean you can't do it. Just means you can't require it of your employees.
I don't know. I think it was pretty broad. That's what the opinion said. It was pretty broad, and enjoined enforcement of this, saying look, no, private companies need to be able. It's free speech. Private companies should be able to hire folks, and as a requirement, have them go to whatever trainings. That person doesn't like that training, they don't have to stay at that job. So that's an example of where, content, the government's now engaging in content moderation, or was trying to, state of Florida, on private companies. And, the First Amendment still prevents that. The government can't regulate viewpoints. And so, forcing Twitter to offer viewpoints, I think that's still a violation of the First Amendment. If you're going to regulate Twitter and force them to air, viewpoints that they wouldn't air themselves.
It brings up...
It's weird because we're talking about Twitter, which is a huge faceless corporation. But corporations have speech rights too.
Yeah. It's on all the platforms they do this now. But we talk about all kinds of stuff on this show. Spotify and YouTube are the two biggest ones where I see it. They will put these labels over the content.
Yeah, I've seen these.
And it's
usually it's like a learn about COVID-19 or something.
Always learn about.
Which is always weird because then I'll listen to that podcast and it literally has nothing to do with, I almost think it's random. It's something. So I don't know. The algorithms.
There's two things that I'll tell you that I've noticed recently, and then I'll tell you a story when I worked at Facebook that will I think give people more context to the internal workings of some of the content moderation. So if we mention the word COVID, Spotify, YouTube, bam, you're getting the label. There are audiences where when they see the label, oh, this is going to be good, right. In some ways, on marketing. Not saying that's good or bad. I'm just saying, I've seen the comments, and for sure, people are oh shit, you got the label. I'm definitely listening. Which is some weird counterculture.
It's like the black flag.
Yeah, just some weird thing that comes out of this stuff. But also, guess what the one topic is that without fail gets suppressed. It's so egregious now that it's impossible to ignore.
I have no idea.
Not the virus. China.
Really?
We put a video up.
Really?
It's like a joke now, right? It's
so what are they labeling it?
There's no labels. You can just see.
It just goes into a black
regular
hole.
Content has kind of an average, velocity and all this stuff.
It's the shadow banning type thing. Yeah.
And I'm sure that there are explanations, whether I agree with them or not, or whatever, and all this stuff. But it's fascinating to watch. When you create a lot of content on the internet, I think you pretty much know, hey, if I post this, it'll be popular. If I post this, it won't be popular.
Right. Yeah, you've got a baseline now.
And there's certain words that just, that they're going to get treated differently. And so what it does is it changes the way the content gets created, right? Because then people start to say, we joke, maybe we should talk about
self-censorship.
And every time it comes up, we'll just bleep it.
Yeah.
So everyone knows it, but we had not done that. But when I was at Facebook, so I'd been in the military. I was working at Facebook, and I worked on the Facebook Pages team.
Okay.
And we had a job where we were supposed to grow the pages, all stuff. But it was a very kind of unique position because the Pages was like the top of the funnel for their business product.
Okay.
So you got a page to be an advertiser, it generates revenue, like all this stuff. And so you'd meet a lot of people around the company. And I remember I met a gentleman. And I can't remember if he reached out to me or somebody introduced, whatever. And he was on a different team, but part of what he did was he was very interested in content moderation, specifically around specific groups from the Middle East that had either been labeled as terrorist organizations or were questionable. I remember talking to this guy, and he was like, "You have no clue. Like a video will come out, and it's like it spreads like freaking wildfire." Right. And it's not just one account, it's uploaded to hundreds or thousands of accounts. So I remember being like, okay, interesting data point. As it is, 3-4 weeks later, a video comes out. And I don't want to describe it in too much detail, but basically it was allegedly had captured a pilot and they basically burned him. And it was all on video, and it was done in like a very, almost like a high school football highlight tape, right? I mean, there's music and this, and it was just so grotesque.
Yeah.
Got uploaded. And there was an internal thing, and I saw it got uploaded, right? And I went, clicked on it. And I remember being like, man, I've seen some crazy shit in my life. This is bad. And it was just getting uploaded over and over and over and over and over, just all over the place. And they had systems internally to try to, whether it's something about the video and the metadata or whatever, and just try to identify it, take it down, take it down, take it down. It was impossible. Wow. Right? Just because it's just the scale of billions of users, one video being replicated over and over again, just all this stuff. And I remember for the first time being like, oh man, if there was no moderation, like if there was nothing and it was like completely wild west, like you wouldn't go on Twitter. Yeah. Right. Because the videos that would end up getting so much engagement and all stuff would be the most extreme things that.
Yeah. Well, that brings up an interesting question, right? Like, because of the sheer number and size of, the sheer quantity of content that is available now on the internet. Back in the 90s, it was like you were on chat rooms and message boards, and there wasn't that many people on the internet. It was like 40 million people or something like that. Like in the 90s, like it wasn't
more people using Bitcoin today.
Yeah, that's right. Absolutely. Like that's where we are. Like, and so the necessity, such that there is one here. It sounds like there absolutely was a necessity for content moderation, especially when you're talking about violent.
And it was like not just, hey, here's violence. It was everyone else should go conduct violence, right? Yeah.
Right. The need for that kind of moderation wasn't as nobody was. You could avoid the content. Let's put it that way.
If you knew was finding on AOL Messenger,
you knew to unsubscribe from that listserv. If too much of that stuff came up, and you could avoid it, I guess. And now it's with billions of people on the internet and on these platforms, it's hard to avoid content.
Well, if you think just the news feed, right? I mean, the invention of the news feed itself of if you were on MySpace and I went to your profile, right? Okay, I navigated there or whatever. But the invention of let's take all this content, let's put it into one specific location, let's start to algorithmically rank it. Okay, still that's people that I somehow have connected with, right? Whether I friended them, on the page, whatever. But then you get share on a Facebook or a retweet on Twitter. And now, technically, yes, if you retweet something, I followed you. But the velocity at which this information can spread is drastically different than, if you had to copy and paste it and go and it's just different. Yeah. And so then you also get into things I don't know if you've seen on Instagram does this a lot. It's like they'll show you a post, and they'll have a little thing at the top, and it'll be like, you're seeing this because you follow this account. Other account. Yeah. And you're like, every once in a while, I'm like, oh, good new account. Other times I'm like, this is kind of weird.
That's the reason I quit Instagram, actually, among many other reasons. But yeah, it felt like I was just grist in their advertising mill. Yeah. And it sucked because I liked, I'm a photographer, amateur photographer. And so I followed, just photographers basically. And like, that was, accounts that had, good artistic merit.
They love you guys. They got the camera advertisers.
That's right. But it was just like, it was too much. Like,
over and over again.
It was too in your face. And so now, so applaud them for putting that out there and saying like, hey, you're seeing this because then I was able to make a decision to not use the service anymore. But so we'll see how long they keep doing that.
Yes.
And I don't know if that's something that, that Congress wants to do. I mean, I know they've been holding tons of hearings on, the algorithms and mental health and social media. And, eventually I guess Congress is just going to have to try and, pull the trigger and pass something to regulate, and then we'll work it out in the courts.
So weird to me. It's classic grandstanding to some degree.
Oh, for sure.
It's always like this. I have a 9-month-old daughter, right? So like when I see the hearings and they're like teenage girls, mental health, I'm like, by the way, yes. But so is the 65-year-old man who's on the same platform. Like they're getting the same garbage as well, right? And like, sure, I get like one is, self-image and body and you're in a kind of malleable part of your life. And like, so there's a difference to a degree. But in some way, it's like, no, this is like a humanity thing. Yeah. Right? If you sit and you just doom scroll all day long, like that's going to fuck with your mind.
It has a serious effect on people's mental health. It's tough. Yeah. And people are not designed to have this like constant feed of information about the world all the time, right? Like we're not omniscient. Like we developed and we evolved in these like tiny little communities, right? Where it was like you could like max out your relationships at like 100. Right? Or something like that. I think there's been some like studies about, networks and stuff. And, basically like, individual humans, top out. Like
we got so many.
Yeah. Where you can really like service them and, and know each other well and create a society around that without some kind of scaling solution. So we're not meant to have all this information, but here it is.
I've noticed a trend in communication that maybe I wasn't paying attention before or whatever. But I now regularly get emails and people will say, hi, Pomp. And then there's some qualifier as to how I know them, what they do, or where we met. And then whatever the email's about. And like, I'm sure that, if I walked up to somebody randomly on the street 20 years ago or something, right? And we started talking, I said, oh, remember we met, whatever, right? So it's not that like this is some brand new thing.
Right.
But it's almost like there's this expectation that the people you communicate with actually may not remember you or whatever. And it feels like that is it's sad in a way. But it's just the nature of like, how many emails do you get? How many people on social media? Like you can't keep track of everyone.
Right. And especially if you haven't met these people face to face. Then you don't.
So now I ask myself, like, damn, should I start off emails with like, and it's almost like you're like, oh, this is definitely a mimetic response, right? Like I see other people do it, I need to do it. But it does change the way that people communicate and interact, and I don't know, it's just a weird freaking thing.
Yeah, and I don't know what the answer is. But look, like the conversation needs to be had, and I think ultimately the answer is going back to the internet and voiding content and stuff. Like as long as there are forums and places where people can go to find the content that is not mainstream and that is being suppressed by these platforms. Like the alternate forums exist. And maybe one day those alternate forums and the ideas on those alternate forums catch, more mainstream, acceptance, and then it shifts and the bigger platforms are now, just like you were saying with Hunter Biden's laptop and, the lab leak theories and stuff. But as long as there is a forum somewhere for ideas, maybe that's the answer. As long as you're not totally suppressing every forum. There was Gab and there's Truth Social and, there's 4chan and 8chan and 12chan and whatever chan it's up to now, those kind of seedy parts of the internet, if you want to call it that. exist where, those non-mainstream ideas can be discussed. As, distasteful as the mainstream finds them, or you and I would find them, the fact that they exist, that's good, and that should be. There's a market for it, and even if it's small, and so because battling network effects is hard.
Yeah, battling network effects is hard, and it's really hard even when when it's a level playing field, and then when the network, the owner of the network is using that network, it's tough. It's tough to beat. The place I want to end on, you spent a bunch of time, First Amendment, many other legal issues, but if somebody wants to go learn more about the First Amendment and kind of how its role in today's modern society, I'll give one suggestion, and then I'd love to hear from you where they can go. Mine is just go read the First Amendment.
Yeah,
right. Like I'm always surprised. By the way, I don't have it memorized or anything.
Yeah.
You don't have to be an expert on it, but literally just go read it one time so that you know what's in there. It's probably a good starting point. But are there other places that you would suggest people to go and get educated, or things that you feel like are good resources or anything?
Let's see. Definitely start with the First Amendment and read that. It's not going to give you too much clarity, though. As there are lots of provisions of the Constitution that we don't have much clarity on. And then funny story real quick about that is I have little pocket constitutions that I keep around the house, and my son, I took it to show and tell one time for it was Memorial Day or something like that, something about America. And then I also have my law books and some treatises from law school and stuff. And these are 1,000 pages and 10 times the size of the pocket constitution. And, my son saw it and was like, oh, that's the Constitution too? I was like, well, yeah, that's all, everybody fighting over what that little book and those little words mean is right here. So,
it's a great way to look at it.
Yeah, there are tons of treatises you can go and look at. That's probably too high level. If you're coming at it from a perspective, from a digital assets perspective, Coin Center has a lot of great explainers. If you just go to their website, they have a lot of educational material, and they've put out some really good analysis of DEXs, decentralized exchanges, and the First Amendment. I would suggest just checking that out and see what Peter Van Valkenburg and Jerry Brito have written over there, because they're pretty good at laying out the relevant doctrines, First Amendment doctrines that apply to digital assets. That's a good place to start.
Awesome. And then for you and your practice, what do you specialize in, or if folks want to reach out, where can they find you?
So I'm an appellate attorney, which means whenever there's an appeal of a judgment or an order, you want to reverse it or uphold it, that's where I get involved. And sometimes I'm involved earlier during the litigation. We're anticipating, appeals. So I do a lot of briefing and researching and writing, and that's, kind of where I came into Bitcoin and digital assets, is I've now started to write and research on issues like the First Amendment that intersect with Bitcoin. And so you can find me at bitcoinbrief.io is my newsletter, my legal research newsletter, where I cover a lot of these topics. I've written some pieces for Bitcoin Magazine. If you just go to their search author page, you can find it. I'm on Twitter at WA Daniel. And if you go to Florida Bar's website and put in my name, William Aaron Daniel, you can call you can I'm doxing myself, I'm out there, I'm here's my face, you can find my office, call my office. Yeah.
I do love a good person to come up to me in some social setting and say I'm so and so on Twitter.
Yeah.
And my wife always laughs. She's like, it's always Crypto Panda or something. Right. You're how'd you go with that name, man?
Yeah. No, again, the NIMs are important. Yeah. It's, we've been bashing Twitter a little bit, but it's great that Twitter is still,
Twitter's
anonymous.
The most important platform.
Yeah.
One of the most important platforms for sure in America. I would argue that for most people, or many of the people who are listening to this from a business, professional career standpoint, Twitter is what LinkedIn should have been.
Yeah.
which is like, that's where you actually go meet people
Right.
and you have connections.
You have
things like that.
conversations.
Yeah. And it's like cool, yes, the whole like LinkedIn profile of like, what have you done in your career is like cool. But the social aspect is so powerful.
It is. Right? It's really powerful. And it's, again, because you get to stay anonymous if you choose to on Twitter. I mean, I understand it creates a lot of bots.
Yes.
And we've got a big problem. That was
less than 5%.
Yeah, that's what Elon was getting, being his botter about, was all the bots but it's important that we're allowed to have the option to go into these public spaces and have these debates, anonymously, just like our founders did, yes. Right? They were able to publish anonymously and have these really important debates about the direction of our country and the structure of our government anonymously, so that their personalities, they were public figures, some of them, their personalities didn't bias people to the message they were hearing, so they didn't get backlash. It's important that we have these anonymous channels.
I appreciate your time. This is fantastic.
No, thanks for having me on.
I felt like I got a crash course. And my conclusion on many of these things is like, they are way more complex than people on the surface realize.
Yeah.
And in things like Tornado Cash, we're gonna have to wait to get a lot more information before we kind of understand how to play out. But it's concerning times, but at the same time, I think it's important people educate themselves so that they are informed in terms of how the direction of this stuff goes.
Exactly. Couldn't agree more.